In this video, I'm demystifying 5 misleading claims about the USCCA so you can feel more confident about becoming a USCCA member, because you can't have trust without transparency. And for those of you who don't know me, I'm Tom Grieve. I'm not an insurance nerd or salesperson, but I am an attorney who has handled the defense of numerous USCCA members over the years. Let's get into it. Number 1, the most basic thing to know about USCCA membership is that the insurer is Universal Fire and Casualty Insurance Company, not the USCCA. People claim that the USCCA is the insurer, but that's simply not the case. It's USCCA. This is an important detail and an easy mistake to point out that some people make. If you are talking to someone who misstates this, they've either not done their homework, don't know what they're talking about, or both. The USCCA is not an insurance company. It is a membership organization focused on providing education and training resources to like-minded individuals who take responsible firearm ownership and the safety and security of their loved ones seriously. Number 2, people claim that the policy would never provide coverage if you're charged with a criminal act. This is wildly misleading and simply not true. Being charged with a crime means that you as a defendant are protected by a presumption of innocence under the law. At the same time, it is important to note that it is illegal for anyone to insure an illegal act. This applies to a drug dealer trying to insure their $10 million cocaine shipment against theft or loss, or someone trying to insure themselves in the event of a homicide conviction. Insurance coverage is sometimes provided until it's a final decision that a crime was committed, but coverage stops in the event of a conviction. Any insurance company that tells you that they do something different is either not being truthful or they are breaking the law. So yes, coverage ends with a conviction because that's the law. Coverage is triggered by a lawful act of self-defense, assuming that all the other terms and conditions are met and that the incident is not otherwise excluded. If a member is charged with a crime and claims they acted in self-defense, there will very likely be coverage, unless an exclusion applies or some other term or condition of the policy was not satisfied. The insurance company has obviously covered numerous claims in which the member was charged with a crime but alleged self-defense as the defense. Number 3, people will claim that the policy language creates an ethical dilemma for the defense attorney and violates the attorney-client privilege. That is not the case. That language is standard in every liability insurance policy. The law recognizes the unique relationship between insurer, insured, and the insured's attorney and protects the attorney-client privilege. It's commonly known as the tripartite relationship among the insurer, its insured, and counsel retained to defend the insured against claims by third parties. So comments stating that the language is unethical are simply false. And by the way, my firm, when representing a USCCA member, has never been told what to do or what not to do. Number 4, people claim that if you plead guilty, the insurance company has a right to require that you pay back every dime spent. We already covered that it is generally illegal for insurance companies to provide coverage for illegal acts. That's why insurance policies often contain language giving the insurance company the right to recoup benefits paid for acts ultimately deemed illegal, because coverage cannot be provided for illegal conduct, period. While we're on the topic of plea deals, if you are facing murder charges, the deal offered isn't typically going to be to plea down to some sort of minor offense and do probation. This isn't traffic court where you pay a small fine and the points go away. Agreeing to a plea deal in a self-defense case will often mean trading an intentional homicide charge that you're facing that often carries life in prison to a reckless or negligent homicide charge that may expose you to 10, 15, or even 20 or more years of prison. If you wanted to know what goes on behind the scenes in these negotiations, there you go. Number 5, people claim that the insurance company only covers civil matters, not criminal. Let me be crystal clear. The policy clearly affords coverage for a member's criminal defense expenses and even bail. This is different from some other ways to get help with criminal defense expenses in self-defense situations that may help pay your attorney's fees, but won't be able to help you to get home to your family by having coverage for bail expenses. So there you have it. Hopefully this video helps clear up some of the biggest misinformation out there to help you make a better decision if you're looking to join the USCCA. And quick reminder, if you are interested in joining the USCCA, you can click in the link in the description to learn more.
Insurance has been purchased by the USCCA and is one of the benefits of membership in the USCCA. Coverage and benefits are subject to the terms, conditions, and exclusions of the insurance policy issued to the USCCA. Every USCCA member is an additional insured on that policy. Information provided herein is for informational purposes and is not intended to be a representation of coverage that may exist in any particular situation. USCCA membership is not available to residents of New Jersey, New York, or Washington State. Contact Delta Defense's customer engagement team at 1-800-674-9779 with any questions. Delta Defense LLC provides sales, marketing, operations, and administrative support services to the USCCA and is a licensed insurance agency in all 50 states and the District of Columbia, with its principal office in West Bend, Wisconsin. Delta Defense LLC does business as Delta Defense Insurance Services in California. California license number 0M34093.